Common Law Handbook. For jurors, sheriffs, bailiffs and justices. Justice and judgment are the habitation of thy throne. Mercy and truth shall go before thy face. Psalms 89:14. Governments are instituted among men, deriving their just powers from the consent of the governed. Declaration of Independence. Men must be governed by God or they will be ruled by tyrants. William Penn, National Liberty Alliance. It is the duty of jurors, sheriffs, bailiffs, and justices to resist all infringements upon the rights of the people without delay. Thomas Jefferson said, "Whenever people are well informed, they can be trusted with their own government." Clearly, the government cannot be in charge of deciding for themselves whether or not they should indict themselves on criminal charges. This is precisely why we have so much corruption in our government. It is the duty of the people to stand up as the faithful and wise stewards, Luke 12:42, and bring the servants who think themselves master back into subjection. Common law is common sense. The question each jurist must ask themselves is there an injured party? There is a common law principle which states that for there to be a crime, there must first be a victim, corpus delicti. The state cannot be the injured party. In the absence of a victim, there can be no crime. This is what the grand jurist must discover. The constitutions of most of our states assert that all power is inherent in the people, that they may exercise it by themselves, in all cases to which they think themselves competent, as in electing their functionaries executive and legislative, and deciding by a jury of themselves, both fact and law, in all judiciary cases in which any fact is involved, or they may ask by representatives, freely and equally chosen, that it is their right and duty to be at all times armed, to freedom of person, freedom of religion, freedom of property, and freedom of the press. Quote. Thomas Jefferson, Letter to John Cartwright, June 5, 1824, The Thomas Jefferson Papers, Library of Congress. Grand Jurors 25. It is the duty of the common law grand jury to expose all fraud and corruption, whether it is in the political or judicial realm, and stop it. The authority of the grand jury is found only in the Bill of Rights, therefore it comes from God and not government. Amendment B. No person shall be held to answer for a capital, or otherwise infamous crime, unless on a presentment or indictment of a grand jury. It is in effect a fourth branch of government, governed and administered to directly by and on behalf of the American people. Trial Jurors 12. It is the duty of the jury to execute justice and sometimes mercy. Their decisions cannot be second-guessed. The jury shall have the right to determine the law and the fact. New York Constitution Article 1. Section 8. As understood at common law and as used in constitutional provision, jury imports a body of 12 men. State v. Dalton, Cooley v. Wilder, Hall v. Brown. Jury nullification. The jury has an unalienable right to judge both the law as well as the fact in controversy. John J., 1st Chief Justice, United States Supreme Court, 1789. The jury has the right to determine both the law and the facts. Samuel Chase, Justice U.S. Supreme Court, 1796, signer of the unanimous declaration, the jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, Justice U.S. Supreme Court, 1902. Central to the history of trial by jury is the right of jurors to vote, not guilty, if the law is unjust or unjustly applied. When jurors acquit a factually guilty defendant, we say that the jury nullified the law. The Founding Fathers believed that juries in criminal trials had a role to play as the conscience of the community, and relied on juries nullifying to hold the government to the principles of the Constitution. Trust in the jury is, after all, one of the cornerstones of our entire criminal jurisprudence, and if that trust is without foundation, we must re-examine a great deal more than just the nullification doctrine. Judge David L. Bazelon. There may be no feature more distinctive of American legal culture than the criminal trial jury. Americans have a deep and stubborn devotion to the belief that the guilt or innocence of a person accused of crime can only be judged fairly by a jury of his peers. This notion is a particularly American one, although it was inherited from English common law during the colonial era. Kentucky Resolutions. A series of resolutions drawn up by Jefferson, and adopted by the legislature of Kentucky in 1799, protested against the alien and sedition laws, declared their illegality, announced the strict constructionist theory of the federal government, and declared nullification to be the rightful remedy. Justice. It is the duty of the justice to do justice. In common law, the title justice is given in England to the judges of the King's Bench and the Common Pleas, and in America to the judges of the Supreme Court of the United States and of the appellate courts of many of the states. In the most extensive sense of the word, justice differs little from virtue, for it includes within itself the whole circle of virtues. Yet the common distinction between them is that which, considered positively and in itself, is called virtue, when considered relatively and with respect to others has the name of justice. But justice, being in itself a part of virtue, is confined to things simply good or evil, and consists in a man's taking such a proportion of them as he ought. Bouvier. The source of virtue. Found in Luke 6:19. And the whole multitude sought to touch him, for there went virtue out of him, and healed them all. Therefore, justice is to reflect divine qualities, as we read in Phil 4:8. Finally, brethren, whatsoever things are true, whatsoever things are honest, whatsoever things are just, whatsoever things are pure, whatsoever things are lovely, whatsoever things are of good report, if there be any virtue, and if there be any praise, think on these things. Sheriff. Top cop. America will never be destroyed from the outside. If we falter and lose our freedoms, it will be because we destroyed ourselves. Abraham Lincoln. Justice Scalia, writing for the majority in a 1997 decision, said that the states are not subject to federal direction, and that the U.S. Congress only had discrete and enumerated powers, and that federal impotency was rendered express by the 10th Amendment. He confirmed that the sheriff is the chief law enforcement officer (CLEO) of the county, and also proclaimed that the states retained an inviolable sovereignty. Scalia went even further in this landmark decision, one in which two small town sheriffs headed the feds off at the pass, and sent them on their way. Scalia, in his infinite obligation to the Constitution, took this entire ruling to the 10th power when he said, "The Constitution protects us from our own best intentions, so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day." Obviously, the sheriff is the people's last line of defense against a government gone rouge. The county sheriff is the last line of defense when it comes to upholding and defending the Constitution. The sheriff's duties and obligations go far beyond writing tickets, arresting criminals, and operating jails. The sheriff also has an obligation to protect the constitutional rights of the citizens in our counties. This includes the right to free speech, the right to assemble, and the right to bear arms. Remember the oath. Sheriffs took an oath to uphold and defend the Constitution from enemies foreign and domestic. In the history of our world, it is government tyranny that has violated the freedoms granted to us by our Creator more than any other. And it is the duty of the sheriff to protect their counties from those that would take away our freedoms, both foreign and domestic, whether it is a terrorist from Yemen or a bureaucrat from Washington, D.C. Bailiff. Officers who perform the duties of sheriffs within liberties or privileged jurisdictions, in which formerly the king's writ could not be executed by the sheriff. One to whom some authority, care, guardianship, or jurisdiction is delivered, committed, or entrusted. One who is deputed or appointed to take charge of another's affairs. An overseer or superintendent, a keeper, protector, or guardian, a steward. Spellman. A sheriff's officer or deputy. A court attendant. It is the duty of all above to correct injustice inasmuch as it is in their power to do so. If correction is not possible, it is the duty of the court officers to report the problem to the protectors of the people, the grand jury, in whose hand justice has been entrusted. United States Codes. Remedy of the people when rights violated. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Misprision of treason, USC 18 Section 2382. Whoever having knowledge of treason, conceals and does not make known the same to some judge, is guilty of treason for contempt against the sovereign, and shall be fined under this title or imprisoned not more than 7 years, or both. Bribery, USC 18 Section 201. Bribery of any public official directly or indirectly, gives, offers, or promises anything of value to any person to influence any official act. Conspiracy against rights, USC 18 Section 241. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state in the free exercise or enjoyment of any right, they shall be fined under this title or imprisoned not more than 10 years, or both. Deprivation of rights, USC 18 Section 242. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state the deprivation of any rights, shall be fined under this title or imprisoned not more than 1 year, or both. Concealment, USC 18 Section 2071. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, documents filed or deposited with any clerk or officer of any court, shall be fined or imprisoned not more than 3 years, or both. Clerk is to file, USC 18 Section 2076. Whoever, being a clerk, willfully refuses or neglects to make or forward any report, certificate, statement, or document as required by law, shall be fined under this title or imprisoned not more than 1 year, or both. Deprivation of rights, USC 42 Section 1983. Every person who, under color of any statute, ordinance, regulation, custom, or usage, of any state subjects, or causes to be subjected, any person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law. Conspiracy to interfere, USC 42 Section 1985. If two or more persons in any state or territory conspire for the purpose of depriving, either directly or indirectly any person's rights, the party so injured or deprived may have an action for the recovery of damages against any one or more of the conspirators. Neglect to prevent, USC 42 Section 1986. Every person who, having knowledge that any of the wrongs conspired to be done or are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured. All is mine. Job 41. 11. Whatsoever is under the whole heaven is mine. Ezekiel 18. 4. Behold, all souls are mine. As the soul of the Father, so also the soul of the Son is mine. Exodus 19. 5. Now therefore, if ye will obey my voice indeed, and keep my covenant, then ye shall be a peculiar treasure unto me above all people, for all the earth is mine. Psalms 50. 12. If I were hungry, I would not tell thee, for the world is mine, and the fullness thereof. Proverbs 8:14. Counsel is mine, and sound wisdom. I am understanding, I have strength. Government by consent. Our founders purposely placed the power of the grand jury in the Bill of Rights to make it clear that it belongs to the people, and the government is not to violate it. It is the ultimate power of the people which allows them to consent or not to the actions of their servant government. It also prevents government from unrighteous prosecutions by forcing the government to seek permission from the people before criminal charges can be filed. If the people refuse, it cannot go forward. By understanding this principle, it becomes clear that the government has no authority to control your behavior, and therefore neither do legislators, without your consent. The Declaration of Independence says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. All men decide whether they want to participate in the institutions of men or not." The United States Supreme Court confirmed this when they said, "Every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellowmen without his consent." Cruden v. Neal. There are only 3 ways a court can hear a criminal complaint. 1. One or more of the people sign a sworn affidavit that they have been injured. 2. A prosecutor, on behalf of the government, brings an accusation before the grand jury and the grand jury either indicts or does nothing. 3. The grand jury by its own will can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. and if it finds wrongdoing it can present it to the court and it must go to trial. No one can second-guess the grand jury, unless the grand jury's actions violate another's unalienable rights. Consent and jurisdiction. It's all about consent and jurisdiction. In order to possess liberty, it is extremely important that you understand consent. Our servant government cannot do anything without your consent. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under U.S. Codes 42 and 18, and are liable for damages under U.S. Codes and common law. The Fifth Amendment states, "No person shall be held to answer for a capital, or otherwise infamous crime, unless on a presentment or indictment of a grand jury. Therefore our servant government requires the people to get an indictment grand jury. Judges, servant, have no authority to make a ruling or a judgment on people, master, without your consent." In legal terms, when the judge asks you, "Do you understand?" he means, "Do you stand under the authority of this court?" So, when you say, "Yes," you just gave him her jurisdiction over you. Our U.S. Constitution only authorizes common law courts, also known as courts of record. A court of record removes the power of the judge to make a ruling. His role is that of the administrator of the court. The final decision maker is the tribunal, who is either the sovereign plaintiff or a jury. Remember, the servant cannot rule over the master. Can the clay rule over the potter? Every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellowmen without his consent. Cruden B. Neal. Herein is liberty. If you do not give the court consent, they have no jurisdiction over you. Under U.S. Codes 42 and 18, when you are detained, without your consent, for violating a statute, you have just been kidnapped, and if the judge sets a bail, he just set a ransom, and when the prosecutor confirms the charges, they are all part of a conspiracy, and you can put them in jail and sue them for damages. It's all about consent and jurisdiction. The real law. The common law is the real law, the supreme law of the land. The code, rules, regulations, policy and statutes are not the law. Legislated statutes enforced upon the people in the name of law is a fraud. It has no authority and is without mercy. Justice without mercy is godless, and therefore repugnant to our United States Constitution. Lawmakers were given authority by the people to legislate codes, rules, regulations, and statutes which are policies, procedures, and law, to control the behavior of bureaucrats, elected and appointed officials, municipalities and agencies, but were never given authority to control the behavior of the people. As we read in a U.S. Supreme Court decision, all laws, rules and practices which are repugnant to the Constitution are null and void. Marbury v. Madison, 5th U.S. Legislators simply do not have the authority to rule-make. Where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. Miranda v. Arizona. God breaks down the law as follows. And Jesus answered him, "The first of all the commandments is, Hear, O Israel, the Lord our God is one Lord. And thou shalt love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind, and with all thy strength. This is the first commandment. And the second is like, namely this, Thou shalt love thy neighbor as thyself. There is none other commandment greater than these." Mark 12:29-31. Although it is a sin, punishable only by the judge of the universe, to break the commandment to love in your mind, words, and deeds, it does not become a crime punishable by man until your words and deeds are expressed in actions that injure another. Thomas Jefferson said, "I would rather be exposed to the inconveniences attending too much liberty than those attending too small a degree of it." If one of the people exercises his free will to do such things as carry a weapon, travel, practice law, park without depositing money in a meter, use hemp, pharmaceuticals, alcohol, vitamins, minerals or any other substance for medicinal or recreational purposes, legislators do not have the authority to impose upon the people a fine, a license, or make such rights a crime. Rights and sovereignty. Only people are sovereign and have rights. Bureaucrats, in their capacity, are not sovereign and have no rights. They have authority given by the people and are subject to the statutes. The state cannot diminish rights of the people. Hurtado v. People of the State of California. The assertion of federal rights, Bill of Rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis v. Weschler. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Scherer v. Cullen. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Yick. Woe v. Hopkins. To deprive the people of their sovereignty, it is first necessary to get the people to agree to submit to the authority of the entity they have created. That is done by getting them to claim they are citizens of that entity. See Constitution for the USA, 14th Amendment, for the definition of a citizen of the United States. Licensing liberty. No state shall convert a liberty into a license, and charge a fee therefor. Murdoch v. Pennsylvania. If the state converts a right, liberty, into a privilege, the citizen can ignore the license and fee and engage in the right, liberty, with impunity. Shuttlesworth v. City of Birmingham, Alabama. Remedy for every injury. Every right when withheld must have a remedy, and every injury its proper redress. William Blackstone. In the third volume of his Commentaries, page 23, Blackstone states two cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded. And afterwards, on page 109 of the same volume, he says, I am next to consider such injuries as are cognizable by the courts of common law. And herein I shall for the present only remark that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime tribunals are, for that very reason, within the cognizance of the common law courts of justice, for it is a settled and invariable principle in the laws of England that every right, when withheld, must have a remedy, and every injury its proper redress. 5 U.S. 137, Marbury v. Madison. The government of the United States has been emphatically termed a government of laws, and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Marbury v. Madison. That statutes which would deprive a citizen of the rights of person or property without a regular trial, according to the course and usage of common law, would not be the law of the land. Polk vs. Henderson. The right to be let alone, the most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Olmsted v. U.S.